This is William and Lonsdale, a podcast about the legal ecosystem and the fascinating people who make it tick. Today, your host Michael Green speaks with the Honourable Justice Lex Lasry, former Justice of the Supreme Court of Victoria and current Justice of the Supreme Court of the Northern Territory. Lex is one of Australia's most recognisable criminal lawyers, a leading barrister at the Victorian Bar before his appointment to the bench, and a long-time opponent of the death penalty. Even though his father was a solicitor, as a child, Lex had zero interest in becoming a lawyer. He was, in fact, set on being a dairy farmer. But despite that, and what he describes as a lacklustre academic record at secondary school, Lex got into law at Monash. But he was still not particularly inspired or engaged, and after failing a couple of subjects in third year, the Dean wondered if perhaps he should consider a different path.
No, what happened was I'd had a very difficult third year. Unsurprisingly, even now, I failed jurisprudence and property. I was given 2 supplementary examinations in those 2 subjects. Enid Campbell, she was the professor in charge. So she pulled me up to the office after the exams and said, well, we're going to give you SUPs in property and jurisprudence. But look, Lex, do you really think the law is for you? And I took that to mean what she meant it to mean, which is do something else. So I drove from the Monash Law School to the Brighton Police Station and got the application form. Went home, confronted my mother with the proposition, who became apoplectic at the prospect and ultimately persuaded me to finish my degree if I passed the SUPs, which I did.
Our guest this morning in Lives in the Law is His Honour Lex Lasry, retired Judge of the Supreme Court of Victoria and a Judge of the Supreme Court of the Northern Territory. Good morning, Lex.
Good morning, Michael.
Thanks
for having me, as they say.
It's great to have you. Back to the start, Lex. A boy in Healesville in the 1950s. Healesville at that stage, I guess, was a small country town, and your dad was a solicitor in that small country town.
He was.
Were you always going to be a lawyer? Were you following in your dad's footsteps?
No. The law, in those days, the law meant absolutely nothing to me at all. It's just what he did. That was all I knew.
Healesville was a bit of a hotbed of political controversy at the time. There was allegedly some communist cell there.
Yes, well, I mean, you have to sort of put it in the context of the time. So it's the 1950s. There'd been the Labor split, there'd been the National Civic Council, there'd been Santa Maria and others that resulted in the DLP being set up. And anyone who was to the left of centre was part of that fractured situation at the time, and the other obsession in the 1950s was communists, and that arose during a dispute in the town.
Why would they look at a small country town, a quiet country town east of Melbourne, and think it was a hotbed of communism?
Well, it arose because the local doctor, a fellow called Arthur Deary, who was a Hungarian Jew refugee and who was our family doctor, a most lovely man, he was an honorary doctor or a visiting doctor at the Healesville Bush Nursing Hospital, and he was sacked because he was accused of carrying out abortions, which in the 1950s, late 1950s, early 60s, was not a good thing to be doing. He denied that. So they sacked him, and that really split the town because he had a very strong following amongst his patients. My father, in effect, became his lawyer, and both Arthur Deary and Ian Lasry were accused by many in that town of being communists.
I was going to say strange times, but maybe it's not that different from today, actually.
No, the circle seems to have turned again, Michael, I think.
It does seem to be heading in that direction. Moving on, Lex, school. Were you a keen student at school? Were you a kid who did well at school and topped his grade and that sort of thing?
No, nothing like that. I was a good student at primary school. Healesville Primary School was a lovely part of my life, but secondary school was a lot different, and no, I wasn't a good student at all.
And you boarded during some of secondary school at least?
Yeah, I boarded through the first 3 years of it.
Did you enjoy boarding?
No.
As simple as that.
Well, I was a spoiled only child, and I was 11 and a half, and the boarding school was a bit of a shock.
You and I are the same age, Lex, and at the same age I went to boarding school too.
Yeah, you probably did better than me.
I don't know, yeah. Anyway, let's move on to Monash University in the late 60s, early 70s, when you did your law degree. Monash at the time, of course, was the hotbed of political upheaval in Victoria at the time, maybe in Australia actually.
It was.
Were you a part of it?
Oh, a small part of it. I fraternised with the Monash Labour Club, which was led by, in those days, Albert Langer and Mike Hyde, and they were the ones who were instrumental in the demonstrations that went on the campus and in the city against the war in Vietnam, and I was part of that.
Was there also demonstrations against the death penalty after Ronald Ryan had been hanged?
Yeah, there were a few, but I actually don't recall going to any. So he was executed in 1967. There probably were, but I don't actually remember going to any demonstrations about that.
No, you and I are contemporaries, and I remember the marches in the city.
There were marches in the city, yes.
Against the Vietnam War.
Yeah. Oh, yes.
But I can't think of anything to do with Ronald Ryan in terms of public displays.
The great Barry Jones sort of mobilised people against the death penalty, but it did no good, of course, because Henry Boltey wasn't interested in according Ryan any clemency.
Your law degree didn't seem to go that smoothly. There was a bump there where you thought about leaving Monash and your law degree and joining the police force. In fact, you even got the papers. Did you fill the papers out and file them?
No, I wasn't allowed to fill them out. So, no, what happened was I'd had a very difficult third year. Unsurprisingly, even now, I failed jurisprudence and property. I was given 2 supplementary examinations in those 2 subjects. Enid Campbell, who I for some reason keep wanting to refer to as Dame Enid Campbell, but she wasn't a dame, but she acted like one. She was the professor in charge. So she pulled me up to the office after the exams and said, well, we're going to give you SUPs in property and jurisprudence. But look, Lex, do you really think the law is for you? And I took that to mean what she meant it to mean, which is do something else. So I drove from the Monash Law School to the Brighton Police Station and got the application form. Went home, confronted my mother with the proposition, who became apoplectic at the prospect and ultimately persuaded me to finish my degree if I passed the SUPs, which I did.
And did things pick up with your degree after that?
No, I just did enough. Look, Michael, I just did enough to fall over the line. That was the best you could say.
But can I say, as a contemporary of yours, most of us just fell over the line because there was no pressure about getting a job. There were jobs for everybody, and therefore you didn't need an honours degree or anything special.
That's right.
Yeah, so
That's right.
I think you're underplaying yourself a bit there, Lex. What about articles? So in those days you needed to get articles.
Yeah, so going back to Hillsville, the lawyer who came in to look after our interests, or my father's interests in the inquiry into the Hillsville Hospital, was Jim Hill, and he was the one of 2 senior partners at Slater and Gordon, and so he was persuaded to take me on as an article clerk.
Do I remember that Jim Hill and his brother Ted Hill, I think, was at the bar, were actually members of the Australian Communist Party?
Yeah, significant communists.
Yes, that was my recollection.
Yeah.
But so he gave you articles at Slater and Gordon.
Yep.
General articles, or did you do a lot of personal injuries work at Slater and Gordon at that
Eventually,
stage?
I spent the first 3 months doing conveyancing with Jonathan Rothfield, which was the most boring work. I don't know why I was put into that, but I was. Jonathan was a lovely bloke, but I didn't see myself as a conveyancer. So yeah, a lot of common law. I mean, they were a personal injuries firm, and they had most of the unions, particularly the big unions, and in particular the tramways. And they liked Jim and Ted's politics, I think.
But you didn't stay there.
No.
When you finished your articles, you went and worked for your dad for 6 months in his practice down in Brighton.
Yeah, which was a conveyancing practice, so it didn't last that long.
Yeah. Conveyancing and probate in those days.
A bit of that,
Yeah. But you come to the bar almost 6 months with your dad, and then you come to the bar. Had you always wanted to be a barrister?
No.
So why did you come to the bar?
Well, because everyone else was doing it. So, but truly, my contemporaries at Monash who had gone this route had gone to the bar. Ian Sutherland, Peter Hayes, various others. So it seemed to me that it would be worth a shot. I didn't fancy working in a large organisation. I didn't see myself as a sort of corporation man. So that's what people were doing. So I joined the queue.
In those days, there was no reader's course.
No, nothing.
You came and sat in the chambers of your mentor,
Correct.
master.
Master, yes.
And hopefully you had a good master who taught you some of the skills of being a barrister.
Yeah. Well, I did have a good master. I liked him a lot, but he was a lot different from me. So I read with David Bennett, who was, among other things, a very good mate of Andrew Peacock's. So we saw a bit of Liberal politicians in those days. And I did articles in 1972, and you might remember Gough Whitlam had just won government, so they were pretty sour-faced people who trooped through David's chambers.
Without a reader's course, how did you learn your skills?
On the job, Michael, really. That was the only way. There were We had occasional lectures from senior barristers who would get up and give a talk and tell us that not to worry too much because most cases are won and lost themselves. And, a few hints here and a few hints there. No role was taken. I don't know that they were compulsory lectures, but no, there was no teaching of advocacy.
And so in some ways it was trial and error.
Very much so, with a lot of error.
Yeah, and pity on the poor clients.
Yeah, yes, that's true. I mean, look, it's true. A lot of cases do win and lose themselves, but there were some disasters, yes.
My recollection of those days was there was a predominance of crash and bash work in the magistrates' court for young barristers.
Yep.
Did you start with that sort of work?
Yeah. I mean, there was more work than we could handle. So I was on the list of Jack Ireland, and his was very much a civil damages list. He saw me in the future as a civil jury, probably defendant's barrister. I didn't see that at all, but that's another story. But yes, we would go to the magistrates' court with 3 or 4 briefs each day and run a long list of crash and bash.
And yet your long career in the law has been predominantly crime.
It has.
How did you get to crime? I mean, I'm assuming it started early days at the bar.
Oh, relatively. I mean, I did, like everyone else, I did crime in the magistrates' court, bits and pieces, a lot of crash and bash. In 1975, the Family Law Act was passed, and I did a bit of work in the family court in the early days of that and hated it. But really, things didn't develop until the late 70s, and I got a brief in a case that turned into a big Supreme Court trial, and that changed everything, really.
And a brief like that just came through the clerk's office? Or that someone knew you?
Yeah, I think it did. I can't really remember. No, it was a public solicitor brief. So I think George Madden himself, who was the public solicitor in those days, was the man who delivered the brief. I'm not sure why he chose me, but I got the brief for the committal. Then I got a junior brief in the trial.
Lex, for someone who's had a long and distinguished career in the law, you said that lack of confidence was a major issue for you early days, and maybe not just for the first year or two, but maybe for the first decade or so. I'm not sure. Have you ever been able to identify why you had such a lack of confidence and what happened to change it? Or was it just a incremental thing, bit by bit you got confident?
I was participating in a bar meeting and got up to speak and had a massive panic attack in the mid-70s, just froze in front of the whole bar. And I thought there and then that was it, my career was over. And that incident haunted me for 10 or 15 years. And that was the primary reason why I sort of lacked the confidence that I should have had.
How did you overcome it?
Well, these things, in the end, I went through a cycle of speaking to psychologists and various other therapists to try to get back to where I'd been. And none of it really helped much. I ultimately took the view that the only way to deal with it was to turn and face it, and that's what I did. I just kept putting myself in situations where I just had to develop the confidence that I needed.
And does this come under the heading that the phrase you've used, fake it until you make it?
Yeah, something like that.
And that's basically what you did?
That's what I did. Look, in those early days, after that happened, I was absolutely devastated. And from there on, for the next few years, I avoided. I mean, here I was, a barrister with a fear of public speaking. You just can't imagine a worse combination. So I sort of dodged situations where that might happen again, and then gradually re-established some confidence. I still don't really know why it happened, but it was an incident in my life that I've certainly never forgotten.
You say that seeing in court a former president of the Court of Appeal, John Winicky, seeing his performance in court maybe gave you some sort of template for what you could aspire to be or how you could aspire to do it?
Yeah, I mean, that brief that I got in the late 70s that became a Supreme Court trial, he was the prosecutor. And so I had the displeasure, if you like, from my client's point of view of watching him prosecute that case. He had not long been appointed silk, and Jack, anyone who knew him and saw him in court knows that he had the most magnificent command of language. He had a presence that I don't think anyone else that I've seen ever had, and he was simply someone I admired enormously. And I never tried to be him, but I watched what he did and tried to adopt some of the techniques that I saw him using.
And I think you mentioned his ability to control the courtroom, control the judge, control the jury.
Yeah.
And that was also something which you aspired to emulate. How do you control a courtroom?
It's got to be by presence to a significant degree. And I mean, I don't think I ever did it in anything like the way he did. But It's hard to describe, Michael. He was a man who people weren't frightened of him, but they were in awe of his performance and his ability, and to a degree intimidated by him. And certainly, senior counsel leading me in that case was no match for Jack, and it's just something that you try to do. I think we all try to do it. I don't know whether I succeeded or not. I'd be the worst judge of that, but he just had that. I mean, I can remember watching him foot up on the chair, folder, notes, final address to the jury, speaking in that way that Jack had because, I mean, you'll identify with this, he played in Hawthorn's 1961 premiership side, and he had that common touch that footballers who've turned to the law had. And people loved him, and he'd laugh at our case and the jury would be giggling with him. It was just an amazing talent. I think I've said many times, he's the greatest advocate I've ever seen.
Just skipping ahead a few decades, in sitting up there on the bench as a Supreme Court judge, did you see barristers who had that ability to control the courtroom? Were you aware that barristers were doing it and the good ones were doing it and were actually did have control? Yeah,
and there were some who were able to do it. I don't think anyone did it to the level that he did it, but there were some barristers with the personality required to have control over what was going on and to always stand their ground to the point where if you were lucky, you could even intimidate the judge. And if you were the judge and you were lucky, you weren't intimidated by the barrister. So yes, I've seen people, but it's changed since those days. The sort of the colourful classical advocates don't seem to be quite as numerous as they used to be.
Correct me if I'm wrong, please, Lex, but I think in those days, someone like a Jack Winicky did civil work, did criminal work.
Did everything.
Yeah, did everything.
Yeah.
And therefore did have sort of a control of the courtroom.
That's true.
And that's completely finished now.
Yeah.
No one does everything now.
Yeah. I mean, another example who's still with us and still working is Phil Dunn. Phil Dunn he's a beautiful advocate. He has that level of control over what's going on. And when he's taken the time to read the brief and think about the case, he does have that level of control over the case. But he's a specialist criminal lawyer, of course.
So what you'd say is to any young barrister listening, if you get the chance, go and watch Phil Dunn.
Yeah, watch Phil Dunn. Yeah, there's a few others. Unfortunately, there are a few others who are now gone. But Phil's worth watching.
So you had a lack of confidence. You were aware of it. You'd had that terrible panic attack and you're working to overcome the lack of confidence. You must have overcome it, Lex, because you had many junior briefs in big matters.
Yes, that's true.
A retrial of Clyde Bollard. I don't know that one.
No, I was a reader. That was my master. He was prosecuting that case.
Okay.
Yeah.
But you were junior to Phil Cummins, who was later on the Supreme Court.
Yes, true.
In a murder trial with John Hassett.
Yes.
I think later on the county court.
Yes, later at county court.
Do you remember those trials? Do you remember?
Oh, yeah, I do.
Did you have a role to play as a junior? Did you have much input?
Well, with Phil Cummins, he had a rule that basically his junior never did anything in court, which I found pretty unfortunate. John Hassett, on the other hand, had me. We divided the case in half, basically, and he did the main stuff, but I did a fair bit. So, yes, I got it. And I always had a policy as a silk that my juniors could expect to perform in court because that's what they were there for.
Yep. You were both prosecuting and defending?
Yes.
As a junior?
Yes.
Did you have a preference?
Probably defending.
There's a nice phrase you used about prosecuting and defending.
Yeah.
Can you remember exactly what it was?
Yeah, when the case is over, the prosecutor's either won because there's been a conviction or he's presided over justice being done. If you're for the accused, you either won or lost.
And if you are for the accused and you've lost, does it knock you about?
It can. It depends. It depends. I always found the highest pressure was in cases where I was convinced, probably almost involuntarily, because I tried not to think about it, but where I was convinced that the client deserved to be acquitted, that they were innocent. That's really when the pressure was on. A great number of our clients in the criminal law aren't necessarily in that position, so that when the case is over and the jury have said guilty, counsel can say to themselves, well, I did the best I could, but the case was overwhelming. So it does depend on the type of case.
I read about you had a murder trial where your client said to you, I'm not giving you any instructions, do your best.
Yeah, he didn't actually say that in those terms, but it was the last murder trial I did at the bar. He just said he wouldn't answer any questions about what happened. So we adopted the putting the prosecution to its proof approach and had a lot of fun.
Am I assuming that he was a experienced player of the criminal law system?
Yeah.
And therefore knew that...
Yeah. I mean, these days, that's all changed too, because in these days, if you were confronted with a client like that, you'd be doing everything you could to persuade them to plead, because the difference in sentence is significant. And by running the trial, you give yourself another 5 or 10 years. So
Yeah.
it's really worth thinking about it.
One of your trials, which I think you prosecuted, Lex, which interested me from a personal point of view, because I actually briefed this guy, I reckon, in Crash and Bashes back in the early 70s, was the murder of a barrister
Yes.
named Roger Wilson.
Roger Wilson, yes.
I can't remember the details of it, except I've got a Porsche motor car in my mind somewhere.
Yes.
What was it?
So that was the John Hassett case, Michael.
Okay.
So John was a permanent prosecutor. I was his junior. On the 1st of February 1980, Roger Wilson was driving home to his farmlet at Narnagoon when he was pulled over by what he thought was a police car. The car contained Chris Flannery and Kevin Williams. They were dressed as police. They handcuffed him, took him to a remote spot and killed him. Flannery said he emptied his clip in his gun into Wilson's head. And the case was basically about that murder being procured by a fellow by the name of Mark Alfred Clarkson over a commercial deal gone wrong, where Wilson had been the lawyer in the commercial deal. But the thing about the case was that there was no body. They never found Wilson. So that was 3 months of murder trial, which ultimately ended in verdicts of not guilty.
The verdict's not guilty. It'd be on the basis that the Crown couldn't prove its case beyond a reasonable doubt.
The defence, quite skillfully in many ways, raised an issue as to whether Wilson was actually dead and produced a witness who claimed to have seen him in a Greek island since the date of the murder. So it was an absolutely fascinating case. It was, all the luminaries were in it. Norman O'Brien was the judge. Phil Cummins was in it. David Harper was in it. John Walker, Michael Rosines, Lex Lasry. I'm kidding. It was a great case. The sort of Penge Bungalow murder type case.
Sounds pretty gruesome. Moving on to the Costigan Royal Commission. That again, so that's late 70s, early 80s?
No, it started in 1980.
And it dominated the headlines for a long time, to my recollection.
It did.
Can you tell us what the Costigan Royal Commission was about and what role you played in it?
Well, Malcolm Fraser was looking for a union to inquire into, and the ships painters and dockers were a perfect candidate because it was a refuge for criminals, there's no doubt about that. So the original allegations concerned ghosting on the wharves, that is, adopting the identity of people who were dead or whatever to get money.
To get their salary.
To get their salary, yes. But as it developed, it soon became an inquiry into the painters and dockers' roles in various crimes, including drugs, armed robberies, things of that kind. And the fun part of it was that every time we pulled the executive of the union into our hearing room, they would refuse to answer questions. So we sent them off, cited them for contempt, and then every now and again we'd go through that process again. But the commission became a sort of de facto crime commission because it turned into an examination of what you might describe as organised crime. And in the latter half of the commission, there was a lot of that sort of work.
And you were junior to a Silk in that?
Yes, so I was junior to Doug Maher. Rex Wild was also a junior. He was there from the start. I was brought in 18 months or so after it started.
And how long did it run for?
It finished in 1982, and then I went to the National Crime Authority in a sort of transitional role.
Can I just, before we get to the National Crime Authority, did anything come out of that Royal Commission? You were in a lot of Royal Commissions, a lot of inquiries, and you have made the comment on one or two of them that they just get, or the results just get put in the bottom drawer somewhere and nothing ever happens. And let's be fair, when we were all younger men in the law, Royal Commissions did have they used to say about them, it was the way of the government burying an issue.
Yeah.
Call a Royal Commission and nothing ever happens. Did the Costigan Royal Commission lead to anything?
Oh, well, it led to the formation of the National Crime Authority, which in turn led to the formation of other criminal investigation bodies at a federal level. The Commission basically pioneered the money trail approach to investigating crime because that's what was done. It basically cleaned up the union. I suppose it really ended the union because the union couldn't survive. So all that ghosting on the waterfront all came to an end. I think it was worthwhile. I think it did produce long-term results. And
yet some of the Royal Commissions and inquiries you were involved in during your career, I'm assuming you would say didn't lead to anything.
Yeah. Yeah, I mean, well, most notably, I was the Royal Commissioner in the inquiry into the Metropolitan Ambulance Service and Intergraph at the turn of the century, literally. And that we worked pretty hard for 2 years, and that really led to nothing, to the point where there are still arguments about O, the O service and its failures. We dealt with that in 2001.
And it's still happening now.
It's still happening.
And they talk about that ramping business still going on now.
Yeah, so I think that's a report that's probably sitting gathering dust somewhere.
Moving on with your career. So after the Costigan Royal Commission, the National Crime Authority is set up.
Yep.
And you accept a permanent position there?
Oh, transitional. I was there for another 6 months to a year, sort of as a handover from Costigan to the NCA.
But you didn't leave
as counsel assisting, yes.
You didn't leave the bar to do it?
No, I was already at the Costigan Commission.
Yeah.
So when the Costigan Commission finished, everybody went back to the bar except me. I stayed on. Our premises became the National Crime Authority premises. I stayed on in a sort of handover capacity.
But you were still a member of the Victorian Bar in that handover capacity?
I was counsel assistant, yes.
Okay, I'm with you. I wondered whether you'd actually left the bar to do it.
No.
So when you come back, so you were effectively away for about 3 years?
Yeah, a couple of years at least, yes.
Was there a handover time for you when you come back to the bar, you sit in your chambers, no one, the phone's not ringing, briefs aren't arriving, and you've got to wait for things to develop?
Yeah.
How long did it take for things to develop?
It's the typical barrister's insecurity.
Yeah.
I took a couple of months, probably took 2 or 3 months, maybe a bit more. The State Crown picked me up after I got back to the bar after that, so I then started prosecuting cases fairly regularly.
And that's straight into the Supreme Court prosecuting murders?
No, County Court. Some Supreme Court, but mainly County Court. We're now talking about the sort of mid to late 80s.
And so that's mid to late 80s. 1990, you take silk.
Yes.
Again, there's a transition there between having a junior practice as a junior barrister to a silk.
Yep.
Some people don't miss a beat, and some people, of course, it takes time for them to pick up a silks practice.
Yeah.
And some people never pick up a silks practice.
That's also true.
How was that transition for you?
Oh, well, I was lucky. I'm in the didn't miss a beat category.
Yep.
Because I had a brief junior to Graham Morris in the police shootings inquests, which went for another 12 months. So I just kept doing that, which was very helpful.
The police shootings inquest, so we're now talking back in the late 80s, early 90s.
That's right.
What was the purpose of it? Were the police, was there a plethora of police shootings?
There were. There were a lot of shootings where members of the Victoria Police had shot people in the course of one thing or another. And so the coroner, Hal Hellenstein at the time, decided to put 8 or so of those cases together and have one big inquest.
So he decided? The politicians didn't decide?
No, he decided. And so I was involved in that. Counsel assisting was appointed. I was junior counsel, and we did the 8 or 9 inquests. Notable among them were the Walsh Street inquest, Tyne and Air, the shooting of Graham Jensen by the armed robbery squad, which precipitated Walsh Street. So it was pretty high-level stuff.
In fact, high enough level for you to go to the US and look at what they do over there.
Yes.
A nice junket for you, Lex.
It was a lovely junket. Yeah, it's the only time I've been in a helicopter. The NYPD flew us around Manhattan in their helicopter. They saw, when we got there and they saw Australians, and we told them why we were there, they could see that they might get a trip out of it. So we got the royal treatment.
And again, back to that issue of inquiries, inquests, what was the outcome of this? I mean, I must say, from what you've just told me, I think well done, Hal Hellenstein, and pretty courageous of him to do it. But did it have an effect?
I like to think so. I mean, I think the approach, and I'm no expert on policing, so I preface what I'm about to say with that, but I think one of the things those hearings led to was the idea that the use of the firearm needed to be a last resort, and there needed to be other ways found to sort of lower the temperature in confrontations. And that's what the police from both NYPD and the FBI taught us. So, for example, in the case of a siege, there was a siege with the Black Panthers in Los Angeles, I think, where the police decided they'd charge in. And as they came in the door, the people inside had an AK-47 lined up on the front door and just picked the coppers off as they entered. So the thing was, you've got to find a way to try to negotiate your way out of these situations rather than just pull a gun and fire it. One of the people we brought out was a hostage negotiator who was a really interesting guy, and he sort of took us through the techniques of hostage negotiating generally with people who are armed and threatening to be violent with the arms they had.
And the Victorian Police took this on board?
Yeah, I think they did. I mean, they hated us because, we were very critical of what had happened. So it was a real standoff. And every day of the hearing, it was a standoff. But I think they realised that there's got to be a better way to do this, and I think they are much better at it now than they used to be.
William and Lonsdale is brought to you by Green's List, one of the leading multidisciplinary barristers lists in Australia. Green's List believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community.
So, Lex, at about the time that you take silk, you also start picking up a lot of work in Canberra.
Some work, yes. Well, I was briefed to do a Commonwealth tax fraud case. That's what took me there in the first place. But other work followed.
Did you spend a lot of time in Canberra, or was it something which, I would have thought that Canberra mainly would have used Sydney silks or Sydney barristers?
Yeah, they did. Yeah, they did. And they were hostile to see Melbourne barristers coming in to what they regarded as their provincial turf. And that trial went on for months. And then they got a retrial after an appeal. And so it went on for months again, phase 2. So I was there over 2 years, really, quite a bit.
And so what about now you, famously is the right word, but you famously appeared in a best-selling book.
Yes.
Called Joe Chinquay's Consolation.
Yes.
Written by one of our former guests, the great Helen Garner.
The great Helen Garner, yes.
So where was that? So after that first 2 years on the tax case, you then were in the Joe Chinquay's case?
Yes, I was. Obviously a separate brief. So my brief was for Madhavi Rao, who was Anu Singh's friend, and what they had done was organise a so-called dinner party, a farewell dinner party, because Anu and her boyfriend Joe Chinquay were departing this earth. They announced, or she announced. So she drugged his food or drink with Rohypnol. He passed out. She injected him with heroin with the intention of injecting herself as well. Somehow that second phase didn't happen and he died and she didn't. And Madhavi was sort of her assistant. So she was charged on that basis and she was acquitted.
Your client was acquitted. And what did Helen Garner have to say about you and your performance, Lex?
Well, I didn't know Helen Garner very well at that stage. So and she came into the case pretty late. She hadn't realised that there'd been an earlier phase, but she was there when that was a judge-alone trial. She was there when the judge announced Madhavi's acquittal, and she was sort of watched because it's an Italian family. The mother of Joe Chinquay was very, very agitated by the outcome. But she rang me up sometime afterwards and said she was writing the book and told me that she was planning to refer to me in a sort of context of me being something like a cold-blooded monster. And how did I feel about that? And I said I'm probably not enthusiastic about that label. But you were just counsel on behalf of an accused person. Why would Helen would say herself if she were here? Maybe she said it when she did your podcast. She became very involved with the family. There was a certain lack of objectivity, I think Helen would admit. Anyhow, she didn't, in the book, I'm not a cold-blooded monster, but I was described as being turgid and lacklustre.
Which would you have preferred?
Cold-blooded monster any day, yeah.
And then just skipping ahead again, Helen has written several books about,
yes,
crimes and trials, particularly trials. One of them, This House of Grief,
yes,
you were the presiding judge in.
Yes, that was in the trial of Robert Farquharson.
Yes.
For the murder of his children.
Did you get a mention in that one?
Oh, yes, I got a mention, but there was nothing turgid or lacklustre about what I did in that case, apparently.
Actually, I'd like to get to Robert Farquharson later because it's a very tragic case. So moving ahead now, so around this time, roughly, around the Canberra time, I guess, you offered a position on the county court.
Oh, no, it was a fair bit earlier.
Was it?
There was a bit of a tactic back in those days. People were appointed silk and then within months were offered jobs as county court judges. And I always thought it was because the government were wanting to get you while you were insecure about your prospects. So it was in that context. But I said no without much hesitation.
You had no interest?
No.
Okay, so we're moving on. An interesting case you did as a silk, and particularly in the context of today of Bondi and terrorism, was a man who the media called Jihad Jack.
Yeah, Jack Thomas.
What was he charged with and how did the whole thing progress and finish up?
Well, he was charged with, I think he was charged with receiving funds from a terrorist organisation, about $3,500 for a plane ticket. But Jack had there's a context which is significant. Jack had been in Afghanistan after 9/11, as had David Hicks. They both went to an Islamic camp called Al Farouk, and Jack was reputed, I think he said himself, he shook hands with Osama bin Laden. So he became, in a sense, the worst of the worst as far as the Australian government and the AFP were concerned. Fortunately for Jack, he was arrested not in Afghanistan but in Pakistan and then sent back to Australia, whereas Hicks was arrested in Afghanistan and deported to Guantanamo Bay. So he was charged primarily, Jack was charged on the basis of what he told police during the interviews in Pakistan.
To the Pakistani police?
And Australians as well.
Oh, yeah.
He was being interviewed. And that was an interview that was completely inadmissible because he was completely overborne. And so the Court of Appeal found. And so
he was convicted at first instance?
Convicted by the jury, yeah.
Yeah.
And then acquitted by the Court of Appeal.
And no retrial?
Well, there was some more charges because for whatever reason, his solicitor, who I won't name, but suggested that he go on Four Corners and tell his story, and he went on Four Corners and told his story, and the AFP found some stuff in what he said on television to justify some further charges. And so I think in the end he got dealt with for false passport or something like that. It was a relatively minor charge. He didn't go to jail. But in Jack's early days, he was a pariah as far as the Australian government was concerned. And John Howard was Prime Minister, and as far as John Howard was concerned, these people were to be locked up and the key thrown away.
And they were very good politics for our government.
They were at the time. I mean, John Howard said of David Hicks that he could stay in Guantanamo for the rest of his life, as for all he cared. And that was in the days when Guantanamo was really just cages.
I was going to say, just to explain the David Hicks thing. So he's an Australian who's in Afghanistan.
Yeah.
Gets arrested.
Yeah. So these are both young white Muslim converts who they've decided that they want to convert to Islam. And young Muslim men are taught that they should go and learn to fight for Islam. And so both Hicks and Thomas went to Afghanistan to learn how to fight for Islam. That's why they were there. I mean, they were dunces, I thought. I saw a fair bit of both of them, and they were not a threat to anyone, really. They just had this view that they should do the right thing by being Muslim men and go and learn to fight.
And so how did it work out for Hicks? Hicks goes to Guantanamo Bay, which from memory is in Cuba.
It is, yes, on the southeastern tip of Cuba.
Yeah, on the tip of Cuba there.
Yep.
The Americans have a prison camp there.
They set up it's really a naval station, Guantanamo Bay, but they set up a make-believe criminal court with make-believe rules. And the idea was that you can't just execute these people. These are all people who've been dragged out of Afghanistan straight after 9/11. I think if they had their druthers, they would have just taken them out and shot them, but no, there's got to be due process. So they created a criminal court, the idea of which was to find everybody guilty and execute them.
And is that what happened to David Hicks?
No, he survived. Nobody's been executed, as it turned out. He was going to stand trial, defended by a former Marine, Dan Morey, and then ultimately they reached a plea deal and he was sentenced and then sent back to Australia.
Lex, in view of what you saw of David Hicks and Jihad Jack and the training that they underwent in Asia to support their conversion to Islam, does it give you any insights or any feeling about what happened at Bondi and those, the men at Bondi who murdered the 15 people?
Well, neither Hicks and certainly not Thomas were in anywhere near the category that the Bondi offenders were in. There were neither of them I ever saw any sign were interested in violence, and certainly not of violence of that kind. In Jack's case, I think he was just looking for something. He was looking to improve his identity. He was looking for something, a change. But Jack was just at times a fool. But the risk, Michael, just before his trial, the alleged terrorist had a part-time job driving a milk truck and he was delivering milk to the AFP building in Latrobe Street.
Did they know that?
Yeah, I presume so. It was just absurd.
Yeah, it does sounds like a farce, doesn't it? Moving on, another area that you worked a lot in, and I suspect didn't get paid, was for people in Singapore and Indonesia who were on death row.
Yep.
And you seem to have a great commitment to that work because of a belief that the death penalty is wrong and should not be imposed. How did you become involved? How did a Melbourne barrister...
In that case?
Yeah, well, in the whole anti-death penalty movement, how did you become one of the people who...
Oh, well, I'm a disciple of the great Barry Jones, who led the the campaign against Ryan's execution. He's a great man, one of the great assets this country has. So I've always been against the death penalty, really inspired by him.
Can I just stop you there for a sec?
Yep.
Why are you against the death penalty? I mean, there are some people, I would assume, who are so terrible, do such terrible things, that it might be best for society if they were eliminated.
Yeah, well, it wouldn't be. What the death penalty does is lower the government of the country that imposes it to the level of the criminal. It's just judicial murder. So as Richard Burke, who has worked in death penalty cases in New Orleans for decades now, says, I don't like it when governments kill people. It's just probably as simple as that. But apart from anything else, Michael, all the literature, all the research demonstrates that it doesn't work as a deterrent. So it's just, to me, it's just as I said during the course of the Van Nguyen case, it's a grotesque way to deal with a member of your community.
Who was Van Nguyen?
So Van was he was the son of a Vietnamese refugee, one of twins that his mother gave birth to after coming to Australia from Vietnam after the Vietnam War ended under Malcolm Fraser's encouragement. He was persuaded to do a run to Southeast Asia. He went. He was at the time 22, I think. Picked up some drugs in Thailand, transited back through Singapore, had one packet strapped to his chest, another strapped to his back, went up to the Qantas lounge at Changi Airport in Singapore, took the one off the front and put it in his bag because it was uncomfortable, fell asleep, heard the call for his flight, ran down to gate C23, it's sort of emblazoned in my memory, went through the security, and as he went through the security, the guard just ushering him through, put his hand on his back and felt the packet, and that was it. So he was charged with trafficking in those drugs. The total was 396 grams of heroin.
And I'm no expert, but that's a small amount.
In relative terms, yeah. But you can die for 15 grams in Singapore.
And he did die.
He did die.
You made comment about his behaviour towards the end of his life.
Yeah, well, it's one of those things that I think a lot of lawyers who've done a lot more of this work than I have would tell you that many of them die a pretty brave death. And Van, the last visit that Julian McMahon, who was my junior, and I had with Van at Changi, he was comforting us. I wasn't coping very well with what was happening. He was fine. No, that's a silly thing to say. He wasn't fine, but he had found some comfort in religion. He'd been baptised a Catholic not long before he died. I think he really believed it. And he faced his death with quite surprising courage for a young man.
And the Bali Nine, you also were involved with them?
For a time, yes. So I also was doing the same work in that case until I was appointed to the Supreme Court, and then I had to bail out of that. So Myron Sukumaran and Andrew Chan were the two principals in that whole operation in Bali. Before Van was executed, Myron Sukumaran's brother rang me up and said, could you look after us as well? And we said we would. So that went on for 10 years, and I was part of it for the first 3 or 4 years.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
So Lex, in 2007, you are offered position on the Supreme Court and you accept it.
Yes.
Any particular reason why? Had you always wanted to be a judge?
No. Look, I well and truly had enough of the bar. I'm not someone who adored the bar. I don't speak in sentimental tones about the bar and the camaraderie and all the rest of it. It wasn't something that I was sorry to leave behind. So in many senses, it was a relief to leave the bar and become a judge.
Okay. Again, it's a transition. Was it an easy transition from being a barrister to being a judge?
Yeah, I thought it was actually. Yeah, others will judge this, but my sense of it from my own point of view is that I took to it reasonably quickly. It's quite different, but on the other hand, you're in the same courtrooms you've been in for 30 years. You're just sitting in a different place, that's all. So you know what's going on and you just have a different role. It's not, my point is, it's not foreign, it's a different angle.
Yeah, okay. As you say, you've been there, working in there for the last 20 years or something.
Yeah.
I'll ask you a question about sentencing. Now,
Yep.
I'll give you a little bit of context about me. The only sentencing I've ever done was on the AFL tribunal, sentencing footballers for misdemeanor, and I found it hard.
Yeah.
Because I would think, but for the grace of God, could go me. Then when I think of people like yourself who've got to, on behalf of the community, sentence people to imprisonment and often for lengthy periods, did you find it hard?
I do find it hard. I think it's just that, as people have said before me, we have this process here where you have to look the prisoner in the eye and speak to them in the first person as you impose the sentence. So at some stage in that process, you're looking in the eye as I'm looking you in the eye now and saying the sentence I will impose on you is life imprisonment and you'll serve 35 years before you become eligible for parole. That's not an easy thing to do, and usually they're expecting it. Their lawyer will have told them what the range is, what the probabilities are, but nonetheless, speaking those words and making those orders is something that I think most judges struggle with. So there's no struggle to be had, really. You've got to do it. If you don't want to sentence people, don't be a judge. But that's what judges do. But it is difficult.
Although I'm assuming there are some people who, in the best interest of society, need to be imprisoned.
Absolutely.
And I guess that might make it a bit easier when you think, well, really, and to help protect society, this person cannot be allowed out.
Yeah. I mean, it's helped by the fact that you know you're doing what the law requires. If you don't do it, then, of course, there'll be an intervention at an appellate level and it'll happen anyway. The contrast I want to draw is that with county court judges, there are a lot of cases in the county court where judges are having to sentence people who are on that cusp. Do they go to jail or not? For offences that probably deserve prison, but there's a good argument why they shouldn't go in at all. I think they're the really difficult sentencing exercises. In the Supreme Court, sentencing murderers, the range is clear and the sentences are usually pretty clear. So in a sense, it's easier because the rules are already laid down.
Yeah, and that obviously makes sense. I'd never thought about that, about the difference between the county court and the Supreme Court, but yeah, that...
Or magistrates. I mean, magistrates are churning through a massive workload and occasionally during the day they'll have a case come up, a criminal case, and the prosecutor says he ought to go to jail. And the magistrate's got to decide under the pressure of all the other work they're doing whether to send someone to jail or not. And that's a big decision on the spur of the moment.
Big decision indeed. You mentioned the Farquharson case, which you presided over, I think, the retrial, not the original trial.
Correct.
Can you just remind us what the Farquharson case was about and whether there's any difference in a judge for you being judge of a retrial as opposed to the original trial?
Well, the case was about Robert Farquharson's, the allegations against him were that he murdered his 3 children on Father's Day. I forget the year now, but it was a Father's Day. He and his wife had separated. He had his children for the day, took them to McDonald's or somewhere in Geelong, and they were driving back to Winchelsea where they lived, and basically as he drove along that highway, he turned right and drove the car into a dam. His defence was, I had a coughing fit and lost control of the car. The Crown case was he did it deliberately with the intention of killing his children in order to exact revenge on his wife. That's what the case was about. He was found guilty twice, and as far as the only difference between the original trial and the retrial was that, of course, in the retrial there was all the transcript from the first trial. So our trial took a bit longer because there was more to be cross-examined about. And also, in our case, the prosecution presented a fresh witness who had not been a witness at the first trial, who was an eyewitness as to what happened. So that was pretty contentious as well.
And in both trials, did the prosecution present some sort of reenactment?
Yes, there was a film. Yeah, we took the jury to the scene. We drove down to Winchelsea so they could see the physical environs. But yes, there was that's also quite a contentious thing. They took a VN Commodore, which was what he was driving, and dropped it into the dam with cameras inside the car in order to recreate what would happen once the car started to float and then sank. Sounds innocuous enough, but one of the things they showed in the courtroom was the view from the back seat as the car sank and as the water came up. And that's the view the kids would have had before they drowned. And I must say, I've always struggled with that.
And were the defence happy that that car was identical to the car that Farquharson was driving on the day? I mean, in terms of where the windows were and all that sort of stuff?
Yeah, well, I mean, there were plenty of variables. And there's been threats in the press of new evidence and a further appeal, which seems to have come to nothing. But yes, that was contentious. There was a lot, and the tracking the car through the grass into the dam and all the rest of it, all of that was the subject of expert evidence, and was contentious, and the jury obviously took the view they took.
And speaking of juries, you, like all other criminal law barristers that I know, are very much in favour of juries.
Yep.
May it change? I mean, trials are becoming much longer. I mean, when you started in the early 70s, major trials took maybe a week or sometimes less than a week.
I'm not sure that's right, Michael. I mean, if we go back to the 80s, that first trial I did, the Jack Winicky case, that trial took 5 months. And, there were drug trials that went on for close to a year. You don't see that so much now. I think the pressure is on practitioners to be a bit more efficient in the way they conduct themselves. But what I do think, as technology improves and as life goes on, I suspect there are aspects of the criminal trial that are becoming very complicated, particularly the scientific aspects, which trouble juries. But I have a confidence that they're properly explained, they're able to understand it all.
And so you wouldn't be in favour of their criminal trials by a judge alone?
I don't mind the idea of it. I've not done one as a judge, but I don't mind the idea of it so long as the choice is made by the accused. Okay. If that's what the accused wants, then I'm fine with that. But as long as someone wants to be tried by a jury, they should have that. And
you've got a saying that you use or advice you give to juries when they're impanelled.
Yep.
Can you just tell us what that is, please?
Yep. Well, the idea is to try to get them to understand the seriousness of what they're about to embark on. And I do tell them, and I'm not the only one who says this, I think I've borrowed it from someone, might even be Paul Coughlin, but I say to them, as I think he does, this task you're about to undertake is the most important civic duty you can perform in peacetime. And it's obvious why. The future of this person is in your hands. You will decide what happens.
And it's true. It's unarguable.
Yeah, it is true.
Yeah.
And, Michael, most jurors see that straight away and are conscientious, I think.
Social media is not corrupting the jury system?
Well, it's a problem, isn't it? I mean, judges give juries warnings at the start of cases not to go on to the media and research the case or talk about the case in social media. And I mean, I had a case not long ago here in Victoria, so 2 or 3 years ago, where I gave the jury that warning: do not go home and look it up on Google. Please, whatever you do, just concentrate on what happens in the courtroom. And the next morning, it was brought to my attention that the foreman of the jury had arrived for the first day of the trial and was telling the other members of the jury what he'd learned on the internet about the accused. I mean, you just shake your head. How can that happen? How can people be so stupid? Anyhow, that's what happened.
But it's not typical.
I don't think it is, no. No, I think if you make them see why it's important, then they will resist the temptation.
Your judicial career, at least here in Victoria, came to an end in 2018. Why did you retire? If I'm counting properly, you were 70 at the time?
No, it's a farcical process. I retired officially in 2018, which is when I turned 70.
Yes.
I then went on for another 5 or 6 years as an acting judge, and that's what I was when I...
Yes, when you...
What happened in 2024.
Yeah, sorry, 2024,
yeah.
Yes.
So I didn't retire, I resigned, because I still had a current commission.
So why did you resign?
Well, I was the trial judge in the trial arising out of the Eastern Freeway crash that involved those poor young police officers. The prosecution had laid charges, including 4 counts of manslaughter, which they announced to me at one pre-trial hearing that they were not pursuing, and when I asked them why, they said they weren't going to tell me and that there would be no reasons, they just weren't proceeding. So I was critical of the prosecution and the DPP for that. I was also critical of the way in which the case had been presented. So there were other charges, heavy vehicle charges and various other things, which I was critical of as well. Ultimately, that criticism led to the accused applying to me for a stay of the proceedings, which I granted.
That's a permanent stay?
Permanent stay, yes. So the manslaughter charges were gone. These other charges I decided I would stay. The Crown appealed. The Court of Appeal wholeheartedly reversed my ruling. They were extremely critical of the ruling, completely disagreed with it, and reinstated that case. So I thought that was the end of it. So that happened. The argument before me happened in March of 23. The Court of Appeal decision was in around August 23. In February 24, I'm told by the Chief Justice that the Director of Public Prosecutions has made a complaint to me about the Judicial Commission in the things that I said both in court and in my ruling, and describe what the complaint was. That meant that from March of 23 up until February 24, at which point I was in the middle of a quite complex bikie murder trial, I'd been continuing to do criminal cases where the DPP was one of the parties, unaware that I was the subject of complaint. I wasn't told by the DPP, and for whatever reason, the Judicial Commission kept it a secret from me as well. That, combined with the way in which the communication that the Judicial Commission sent me, led me to the view that I was a little bit behind the eight ball so far as getting a reasonable hearing was concerned. And I just decided I was not prepared to go through the process. I was 75, 76. I'd had enough. So the best way to resolve it, bring it to a head, was to quit. So that's what I did.
For my enlightenment, and maybe other people as well, who or what is the Judicial Commission?
No, you'll have to ask them who or what they are, Michael. I don't really know. There's an Act of Parliament. There are people who constitute the Judicial Commission.
Are they politicians or are they public servants?
No, I'm not sure what they are. I mean, I think they bring in probably lawyers and other judges to participate in particular cases. The idea is to punish misbehaviour by judges. I didn't think I was guilty of any misbehaviour. The sort of criticism that I made of the DPP was this kind of criticism that I've got myself over the years from judges, and wouldn't have dreamed of making a complaint about it. Plus the matter had been dealt with in the Court of Appeal. So to me it was something I wasn't prepared to take part in the dance. I just decided I wanted out.
And so out it was, although you have continued to do some judging.
Yes.
In the Northern Territory.
Yes.
Their system is slightly different. There's only 2 tiers, not 3.
Yes, there's
Magistrates Court, Supreme Court.
That's right, there's no county court equivalent.
And so trials and matters that here in Victoria might be done in the county court.
Yeah.
There are done in the Supreme Court? Or?
Yeah, all jury trials in the Supreme Court.
All jury trials in the Supreme Court.
So the Supreme Court do everything. They do murders, but they do sex cases, they do theft and burglary, they do everything that's indictable.
And have you done much work up there?
Yeah, I did. Last year I did 3 months up there. So I'd go up month on, month off for 3 months. And it's terrific. The atmosphere is good. The judges are great. The building is beautiful.
You're always in Darwin, not in Alice Springs?
It's open to go to Alice Springs. I haven't done that yet. Yes, so I was always in Darwin. It's terrific. And Darwin in June, I can recommend to anyone. It's fantastic.
And culturally different to Victoria? I'm assuming it would be, actually.
Do you mean generally or?
Yeah, I mean generally, yes, and then how that then flows through into the legal system.
Yeah, well, I mean, you see First Nations people everywhere in Darwin. I think the Indigenous community is probably 25 or 30% of the population up there. They are 85% of the prison population, and that's a lot different from what we see down here. I mean, I welcome that. I like learning about Indigenous culture and that kind of stuff, and I haven't had much exposure to it until now.
No, we don't get much exposure in Victoria, do we? And when you go to Darwin, it's very different, and probably something we all should do is learn more.
Yeah.
Yeah, absolutely learn more. I remember hearing an Aboriginal guy speak at a function I was at some stage, and he said, you people have been here a couple of 100 years, I guess. We've been here over 60,000. He said, you could probably learn something from us.
Yeah.
I thought that was reasonable.
It's a fair point.
We've got to get on to the juicy stuff now, Lex.
Yep, okay.
And this is the Lex Pistols.
Yes.
So who were the Lex Pistols and how did your name come to be part of a rock band?
Well, it happened reluctantly. So the Lex Pistols were a bunch of lawyers who liked to play music. Others included John Champion, Michael Carl, Alistair McNabb, Justin Whelan, Paul Connor, and a singer we had at the end, Reggie Ewing, who was fantastic. Look, it was just a garage band, really. But we lasted for, I don't know, 20 years, 15 or 20 years. And then it just sort of fell over at the end, and so we don't play anymore.
Are you playing any music yourself now?
No, I'm not, no.
But you are a guitarist?
I'm a drummer.
Oh, sorry, yeah, that's right. I see you're at school with Ross Wilson of Daddy Cool.
I was.
You didn't get invited to join Daddy Cool?
No, we did one concert with him. We ran a concert for Peter Grester, the journalist who got locked up in Egypt. We ran a fundraiser, and he came along with what was left of Mondo Rock, and fantastic. I mean, he was great. So yeah, I occasionally see him. He denies that he was at school with me. He says he can't remember me. So, but I remember him quite vividly.
I'm sure if he's probably the coolest kid in the grade, so everyone would remember him.
He is very cool.
And your other great hobby is racing cars.
Yeah.
And specifically MGs, or maybe Porsche's got to mention there as well.
Yeah, so I played footy for a few years after I left school and I wasn't much good at it, so I went motor racing, and that had a lot to do with the poor performance towards the end of university. So I basically raced sports cars, touring cars on one occasion, and towards the end, 2 or 3 Porsches.
And racing cars, is this on circuits like Sandown?
Yeah.
It's not the ones that go up the hill and that hill climbing?
No, we've done that. I've done that as well. So I used to run a thing at, we've got a place up at Merrijig. There's a nearby mountain called Mount Buller. They used to run sprints up Mount Buller. We did that a couple of times. But no, mostly Sandown, Phillip Island, Winton, places like that.
Are you still doing it?
No.
Too dangerous?
Too old.
I mean, it's too dangerous because you're too old.
I'd be dangerous. It's hard enough on the road. I saw a sticker on a car yesterday, I think, as it passed me, and the sticker said, "I'm not speeding, I'm qualifying."
To finish off, you also made a comment that if you could turn back the clock, you probably wouldn't be a lawyer.
No.
Why did you say that?
I haven't enjoyed it enough to... I wouldn't do it again. I wouldn't do this again. If I could turn back the clock, I think I'd find something else to do. There are a few things about it. I never thought I was good enough to do it. Perhaps that turned out not quite to be right. I just, reflecting on it now, to have spent a life, which a lot of people do, making a living out of human conflict is not something I'd want to do again.
And yet, as you said to the juries, this is the most important thing you'll do in peacetime.
Yeah.
The contribution that members of the judiciary and the bar as well, and the law in general, in its best cases, not all the time, is absolutely crucial to our...
Absolutely. I'm not saying it's not important. It's just that I don't want to do it again. That's all.
But you must take some satisfaction out of having done it and having made a significant contribution to our community.
Well, other people will judge whether I've made a significant contribution. I don't reflect on that very much anymore. I've got through it. I'm just glad it's over in many senses.
Well, Lex, as a member of the community, speaking on behalf of the community, I say thank you for the contribution you've made. I can't change your mind. I'm not going to try to, but I'm sure we're a better community for having you having made a contribution. Thanks for coming in.
Thank you, Mike. Thank you for saying that, and thank you. It's been a pleasure.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.